Hi everyone, welcome to another episode of Law Beyond Labels. We are truly grateful to you for your support to the first episode, and many of you have subscribed to the channel also. Today I want to talk about a topic that I'm also often asked about as an IP lawyer, which is how to register a trademark. What are the steps involved, how long does it take, how much does it cost, and what is a trademark even. At the very outset, people sometimes get confused between copyright, patents, and trademarks, and they don't know whether what they have invented is it worthy of trademark registration, or is there some other form of IP that they are entitled to get for it. So, at the outset, the difference between these three forms of IP is that trademarks refer to logos, brand names, you know, slogans which are distinctive, which set you apart. Whereas copyright is in the nature of, if you write a book or if you come up with a plot and you give it a concrete shape. So it's for original, literary, dramatic, musical, or artistic works, as the law calls it. And patents is for technical invention, whether they be technological, whether they be in the biosciences, whether they be in any other realm. But basically, the idea is to secure protection for any invention that one has engaged in, for the idea itself, right? Now, that having been said, let's say you are a small business owner, or you run an NGO, you run a school, and you want to trademark the name and logo of the entity. Now, how do you do that? And do you even need to do it? The first thing to be noted is that the moment you come up with some kind of a brand or a logo, you are automatically entitled, after it acquires a certain amount of goodwill, when somebody misuses it. Let's say someone uses your brand name to sue them for passing off, which is a remedy in what we call law of tort, which is civil wrongs, whereby when you can establish that you have goodwill, somebody has misused what you have protection over, and that has caused you some damage, then you can sue them for passing off even without having obtained trademark registration. But let's say you want an additional layer of security and protection, and hence you register a trademark. Now, for this purpose, there are about 45 different classes into which goods and services are classed. You'll have to figure out which class your mark belongs in. This is called the NICE classification. And after that, through the help of a trademark attorney, you'll have to file an application for trademark registration through what is called a user affidavit. This really sets out what kind of. So before that, I should tell you that there can be two ways in which you can file a mark for a mark registration, right? Number one is whether it is on a proposed to be user basis, whereas where you haven't started using it but are thinking of doing it as of now. You just come up with the mark, or it is on a use basis where you've been using it for a while, but now you want to obtain protection because of the goodwill and reputation that has come to be associated with the mark. So you have to file an affidavit indicating, if you have been using it, then what kind of use you put or the mark to, evidence of its use on social media, any news articles, any journals, advertisements, publications, awards, and so on, which the mark has garnered so as to be able to show its use, because that's the way to establish distinctiveness. Normally speaking, marks may not be registrable unless they are distinctive, right? So the mark has to be arbitrary. Like, for example, if you think of the word Apple for computers, right? That's a distinctive mark. Why? Because Apple in and of itself, everybody knows of it as a fruit, but people wouldn't think of it in the context of a computer system. So when you thought of it that way, then it's entitled to protection. But let's say it's a more generic kind of a mark. For example, the word pure, where something related to pure for a liquid, that may not itself be entitled to registration because it's a quality of that liquid. So there, this use evidence becomes important. Now, once you file, and the fee can be anywhere between roughly 5 to 10,000 rupees, depending upon this is a basic amount. It depends on the number of classes you are applying for. If you are a startup or an MSME, you also get a discount. That is the government fee, and the legal fee that your attorney will charge you is a separate matter. After you apply, the registry then has to process that mark, which takes about 6 months, after which they issue what is called a first examination report. That indicates what other marks are there in the register with which this mark that you are seeking to register may conflict, or what are the other grounds on the basis of which the mark may be denied registration. Let's say, for example, if it's something which is disrespectful to a particular religion, and that could be a ground. Then you need to give evidence of why you are not hit by those objections. After that, typically a hearing is also appointed where you have to convince the registrar of this point. Thereafter, if they are convinced, the mark is advertised in the Trademark Journal for a period of 4 months, during which anybody can oppose, and those objections you need to overcome. And for that you need to again file evidence and show why they are unsustainable. And ultimately, once you are able to overcome all of this, then the mark proceeds to registration. Typically, the whole process takes around 18 to 24 months, if not longer. The reason for that is due to the voluminous backlogs that the trademark registries are dealing with. Hence, it takes time for them to process this. I hope this is helpful to you, and if you have found this content useful, please do like, subscribe and share.